Good morning, good afternoon, good evening, wherever you're at. This is Dr. Diane Sanchez, and I am going to cover employee rights and responsibilities. I will tell you this is a long chapter, and this webcast may be a little long. You may have to come back at it, but I'm going to try to go through as much as I can and as quickly as I can. So the learning objectives for the chapter is to define employment at will and discuss how wrongful discharge, just cause, and due process are interrelated. Identify employees' rights associated with free speech and access to employee records. Discuss issues associated with workplace monitoring, employer investigations, and drug testing. List elements to consider when developing a handbook, an employee handbook. Understand the use of employee discipline in companies and differentiate between the positive and progressive approaches to discipline. Outline the issues and procedures related to employee discharge and termination. So, what is employees' rights and responsibilities? Well, the rights are power, privileges, or interests derived from law, nature, and tradition. And so we have legal rights, obviously, may or may not correspond to certain moral rights, but it opens up to rights as a controversy when it comes to potential lawsuits. Statutory rights based on specific laws or statutes passed by federal, state, or local governments. So various laws have granted employees certain rights at work, such as equal employment opportunity, collective bargaining, workplace safety. These laws and their interpretations has also been the subject of considerable number of court cases because employers also have rights. And then responsibilities. Rights are offset by responsibilities, which are obligations to perform certain tasks and duties. Employment is a reciprocal relationship in that both the employer and the employee have rights and obligations. So, for example, if an employee has the right to a safe working environment, then the employer must have an obligation to provide a safe workplace. Contractual rights. So we have 3 rights based on a specific contract between the employer and the employee. So the first one is employment contracts, an agreement that formally outlines the details of employment. Now, those items are usually spelled out in a written employment contract, or it's usually in a handbook. Most employment contracts really are for the higher level CEOs and such. But the employer handbooks and policies are disseminated to the employees, and they may see that as a contract. But really, we don't have a lot of employment contracts because we want to make sure we maintain at will, which I'll go over. Then there's the non-compete agreements. And those non-compete agreements are employment contracts that prohibit individuals who leave an organization from working with an employer in the same line of business for a specific time. So if you work for Microsoft and you leave Microsoft, they may say you can't work at Dell or Apple for 2 years. That's a non-compete. And then there's protection of intellectual property. So, a contract is protection of intellectual property and trade secrets. So it's the right to keep trade secrets confidential, the right to have employees bring business opportunities to the employer first before pursuing them elsewhere, a common law copyright for works and other documents prepared by employees for their employers. And here is the provisions of employment contracts. Really, I've only seen them at the C-suite. Now, now more and more it's in information technology, especially when it comes to not soliciting certain individuals or not, intellectual property and trade secrets. Okay, non-compete. Here's the different kinds of non-compete agreements, which is non-piracy agreements. That's really kind of an interesting one because it bars former employees from soliciting business from former customers and clients for a specific period of time. Non-solicitation of current employees can be incorporated in an employment agreement. These are written to prevent a former employee from contacting or encouraging coworkers at the former employer to join a different company, often a competitor. And then intellectual property and trade secrets, as I talked about, really to the right to keep trade secrets confidential. All right, employment contract clauses. Oh, I think that was it. We talked about this already. Oh, yes. Thank you. Implied contract. The idea that a contract, even implied or unwritten one, exists between the individuals and their employers affects the employment relationship. The rights and responsibility of the employee may be spelled out in a job description, an employment contract, HR policies, and handbooks, but often they are not. That is what's considered implied contract. And some courts' decisions have held that if an employer hires somebody for an indefinite period and promises job security, the employer has created an implied contract. All right, risks in affecting the employment relationship, and we're going to go into detail about each one of these. Employment at will, wrongful and constructive discharge, just cause, due process, distributive and procedural justice. So what's employment at will? Well, it is a common law doctrine stating that employers have the right to hire, fire, or promote whomever they choose unless there is a law or a contract to the contrary. And that's why a lot of employers don't have employment contracts with their employees, because they want to maintain the employment at will, which gives the employer the right to hire, fire, demote, or promote as they choose. What does this do for the employees? They have the right to quit and get another job under the same constraints. So again, this employment at will, if you have a contract, that all is something else is written into the contract, which is, that they have the right to do something or don't do something. Now, what really has constituted rational and recognized rationales for hearing employment at will cases? Well, public policy exceptions. This exception to the employment at will holds that employees can sue if fired for a reason that violates public policy. For example, an employee refused to commit perjury and was fired. The employee can sue the employer. Implied contract exception. The exception to the employment at will holds that employees should not be fired as long as they perform their jobs. Long service, promises of continued employment, and lack of criticism of job performance imply continuing employment. And then good faith and fair dealing. The exception to the employment at will suggests that a covenant of good faith and fair dealing exists between employers and at will employees. If an employer breaks this covenant, By unreasonable behavior, the employee may seek legal recourse. And so these have all been tested in the courts. And it really is, testing the employment at will components. Okay, employment at will restrictions. Employers that run afoul of employment at will restrictions may be found guilty of wrongful discharge, which is a termination of an individual's employment for reasons that are illegal or improper. Constructive discharge is closely related to wrongful discharge, which it's deliberately making conditions intolerable for an employee in an attempt to force them or get them to quit or resign. And a lot of the EEOC charges now have constructive discharge, where the Employee Equal Employment Opportunity Commission, the EEOC, is really seeing if the employer has really violated employment at will through constructive discharge. And here's the keys for preparing the defense against wrongful discharge. Is you've got to put together accurate performance evaluations, develop documentation to justify the dismissals, provide employees a written warning, provide written grounds for termination decisions, involve more than one person in the dismissal decision. Employment at will. So what do the courts look at? They look at a criteria for fairness. And it's two things in evaluating just cause at employment at will fairness. Just cause and due process. Just cause is reasonable justification for taking an employment-related action. And due process is the requirement that the employer use a fair process to determine employee wrongdoing. So it's got to have a process where it allows the employees to explain and defend their actions against the charges or the discipline. This is a great chart. It's criteria for evaluating whether you have met just cause and due process. And if you're ever in front of a jury, this is the questions they will ask. Was the employee warned of the consequences of the conduct? Was the employer's rule reasonable? Did management investigate before disciplining? Was the investigation fair and impartial? Was there evidence of guilt? Were the rules and penalties applied even-handedly? They're going to look at past practice there. Was the penalty reasonable given the offense? And then due process considerations is, how have precedents been handled? So did you treat everybody the same? Is a complaint process available? Was the complaint process used? Was retaliation used against the employee? Was the decision based on facts? Were the actions and processes viewed as fair by outside entities? So this is a great chart that many HR practitioners use to ensure that they've met the criteria for just cause and due process. Now, let's talk about organizational justice. So, organizational justice means that most people want to feel that their organization treats employee justly. And so you've got these concepts that you've got to try to meet. Distributive justice, which deals with the question, were outcomes distributed fairly? Disciplinary action based on favoritism, when some are punished and others are not, would likely be viewed as unfair. Fairness is dependent on employees' perceptions and is ultimately a subjective determination. The second rung you've got to think about is procedural justice. Was the decision-making process fair? Due process is a key part of procedural justice when making promotion, pay, discipline, and other HR decisions. If organizations provide procedural justice, employees tend to respond positively, thus benefiting the organization in return. And then the third one is interactional justice. It's based on the way a person interacts with others. For example, if a manager is perceived as rude and insults another person, their relationship may be affected negatively. But if the manager treats the other person with respect and shares information truthfully, then individuals are more likely to see justice in interactions with managers. So how do you do this? You really implement an open door policy. Anyone with a complaint should be able to talk to their manager, an HR representative, or even an executive. And the probability of being mishandled really diminishes when you have an open door policy. Non-union firms really benefit from having a formal complaint procedure that's well defined. So, what's ADR? Well, that's alternative dispute resolution, and many companies use several of these: arbitration, peer review panels, ombudsmen, to handle disputes between management and employees over work issues. Let's talk about each of them. Arbitration. Arbitration is using a neutral third party to make a decision, and some companies make it compulsory arbitration, which all disputes will be submitted to arbitration before you can file a lawsuit. Employees waive their rights to pursue legal action until the completion of the arbitration process. Now, this may change state by state. So, it requires that employees sign a pre-employment agreement stating that all their disputes will be submitted to arbitration, and that the employees waive their rights to pursue legal action. Many states have laws that really don't allow for arbitration, and California comes to mind. Then peer review advantages. You have some employers allow their employees to appeal disciplinary actions to an internal committee of employees. The panel reviews the actions and make recommendations. This reduces lawsuits. It really helps with due process. It lowers costs. And then it helps management and employee development. And then the ombudsman. A lot of organizations have this. It ensures process fairness. Employees outside the normal chain of command who act as independent problem solvers for both management and employees. They address employee complaints and operate with a high degree of confidentiality. And they really serve as mediators. They develop appropriate and fair outcomes. They help settle disputes that, can effectively work to interact with each other on the job, especially employee to employees, in which a lot of conflicts happen between employees to employees. All right, right to privacy. So let's talk about managing individual employee and employer rights. So employees who join an organization in the United States bring with them certain rights. Freedom of speech, due process, protection against unreasonable search and seizure. Although the U.S. Constitution grants these and other rights to citizens, over the years, laws and court decisions have identified limits on them in the workplace. And so rights of privacy, an individual freedom, that is unauthorized or unreasonable intrusion into somebody's personal affairs. Change in nature happens at the workplace because of the new internet communications, blogging, Twitter, and there's a lot of blend between the work and personal life. So the nature of privacy issues in the workplace is becoming very complex. And then you have the use of technology that monitors employees' actions. That increases concerns for employees. They feel that it violates their privacy rights, but it really is part of what a company can do. All right, what about the privacy of medical records? It's really important that employee medical records are held in confidence, especially because of the provisions with the Americans with Disabilities Act, which shows exactly the essential functions of the job and what kind of physical, mental abilities are necessary for that job. There is also HIPAA in that, which is the Health Insurance Portability and Accountability Act, which contains regulations designed to protect the privacy of employee medical records as well. So you've got to really be cautious in the medical records, and it is recommended that the employee medical records are separate from the personnel files and locked up in a different location. Now, it's important also the security of employee records. It is important that access restriction and security procedures are maintained for the privacy of employee records. And these restrictions and procedures are designed to protect the privacy of employees and protect employers from potential liability for improper disclosure of personal information, such as employee social security numbers, personal addresses, so forth and so on. Now, there is a legal regulation called the Data Protection Act, which requires employers to keep personnel records up to date and keep only the details that are needed. So, and this whole electronic records thing is also a big focus as well, so that we can encrypt things, so we can make it private, passwords on electronic records, so forth and so on. Now, these are the different things that you can have on employee record files. A current file, personnel file that might be 2 to 3 years of employment information. You can have a historical file. Maybe your policies are, hey, we're going to put the historical file 5 years or more. Older documents, non-confidential, non-medical details about benefits. Then there's the confidential file. Those are references, assessments used for promotions, and then medical files, which I talked about. So you've really got to restrict individuals allowed to access employee records, separate them, inform the employees about which types of data are being retained, purge them, and then release employee information only when the employee consents to it. All right, employee free speech rights. Again, the right of individuals to freedom of speech is protected by the U.S. Constitution. However, that freedom is not an unrestricted one in the workplace. So employees and companies need to be aware of the appropriate boundaries. So, for example, there was an example where an employee brought a Confederate flag to work. Well, the courts found that he couldn't do that. He said he had free speech. The court said, sorry, it violated the discriminatory acts perceived as, obviously, going back to the years of slavery. So he was to take out the Confederate flag. So it's those kinds of things that becomes very controversial. And so the best way to handle these concerns is to attempt to have an informal resolution first, clearly outline the boundaries and standards for appropriate behavior in a formalized policy that addresses work expectations, and have a signed non-disclosure privacy agreement. Now, there's the whistleblower and employee protection. Whistleblowers are individuals who report a real or perceived wrong committed by their employers. And so, several of the laws that are affected by this are Sarbanes-Oxley of late, and Dodd-Frank, and the Consumer Protection Act. Let me discuss Sarbanes-Oxley. This is a law that protects whistleblowers in corporate settings. So, for instance, Sarbanes-Oxley is intended to remedy company ethical breaches by requiring organizations to properly report financial figures, encouraging ethical business practices, and providing protection for whistleblowers. But an anti-retaliation provision covers only complaints made to certain entities, such as manager, executive, and a federal regulatory or law enforcement agency. The Dodd-Frank Act also protects whistleblowers and provides financial incentives to individuals who report wrongdoing. In addition to paying fines, a company that is found guilty of retaliation is required to give the individual back his or her job, provide back pay or double back pay to make up for lost compensation, and cover any cost associated with legal counsel. So it's pretty pricey. And then there's the Consumer Protection Act, which is really, again, whistleblower provisions about consumer issues. So, key questions in regard to whistleblowing. When do employees have right to speak out with protection from retribution? And when do employees violate the confidentiality of their jobs by speaking out? Even though the answers may be difficult to determine, retaliation against whistleblowers is clearly not appropriate. Whistleblowing is viewed as a lack of loyalty on the part of the employee, although that may or may not be a correct interpretation. So whistleblowers are often treated poorly by their employers because they are seen as a significant threat to the stability of the organization. That's why an ethical culture that includes reporting mechanisms that encourage employees to tell managers about problems and retaliation policies prevent mistreatment of whistleblowers, and that's beneficial. All right, let's talk about technology and employer-employee issues. And this is a big one. Those of you in human resources, we are all wound up about social media. And so it really is becoming more and more an issue. But there is some real challenges in this, all right, because terminating workers for openly complaining about an employer on social media has come under scrutiny based on recent court rulings. As a result, the National Labor Relations Board has brought suit with other companies, but particularly one particular one who terminated an employee for comments about her manager on Facebook. So the ruling was that it really was protected activity, and that we needed to, it can be done, especially if there's a call to action. So, but there can be policies in place that can limit unprofessional content, things that are inappropriate, absolutely. You've just got to have policies and procedures on your electronic communication. I can't stress this enough. It is so important. And here is the recommended employer actions regarding electronic communications. Develop an electronic communications policy. Communicate the policy to employees. Obtain signed permission from employees. Monitor the business purposes only. Monitor for business purposes only. You don't want to go out on somebody's Facebook to find out about what they're doing on their personal life. And enforce the policy through disciplinary action. Reviewing unusual behaviors. So employers may decide to review unusual behavior by employees both on and off the job. So for instance, if an employee is suddenly wearing many new clothes and spending lavishly, inquiries as to the reason why and the resources used might be warranted. But some of these, another issue is obviously behavior, and some of these behaviors may run counter to the law. So I just caution you to be careful about monitoring employees, but you can if there is unusual behavior. Same with dress and body appearance limitations. Employers may put limits on employees' dress and appearance in some situations, including items such as visible tattoos, certain clothing, and accessory body piercings. But again, those need to be legitimately job related. And I talked about off-duty behavior. That puts the company in legal or financial jeopardy. So if you're reviewing somebody for unusual behavior and you're going out there and searching off-duty behavior, you just need to document why you're looking for the unusual behavior, that it possibly could be job-related as it relates to something like bullying or substance abuse or stealing from the company. All right, workplace monitoring. So numerous employers have installed video surveillance systems in the workplace, and that really does help with employee security, and such as parking lots and garages and dimly lighted areas. But it does also require that employers be careful so that employee rights and privacy do not collide. So things like surveillance extended into employee restrooms, changing rooms, that really can become an issue. It's important that the employers develop a video surveillance policy, inform the employees about the policy, perform the surveillance only for legitimate purposes, business purposes. And then, of course, at the minimum, employers should obtain a signed consent form that indicates the employee knows performance will be monitored and phone calls will be taped regularly if that's what you want to do. All right, let's jump to investigations, and these are the best practices for conducting workplace investigations. Develop a good working plan to respond in times of crisis. Give high priority to confidentiality through investigations. All important incidences should be properly documented, and this can be sexual harassment, workplace violence, anything that potentially is going to be a work-related issue. Specify whether HR or another party will conduct the actual investigation. Investigate problems quickly before evidence can be tampered with. Credibility of individuals providing information in an investigation must be assessed. Use the stories and information collected to identify a conclusion to the investigation. All right, honesty and polygraph tests. Well, we have the Employee Polygraph Protection Act, which is something that prohibits the use of polygraphs, which is a lie detector test, for most pre-employment screening. And it also requires that employees must be advised of their rights to refuse to take a polygraph exam after they've been employed, be allowed to stop the exam at any time, and not be terminated because they refuse to take a polygraph test or solely because of the exam results. So many companies don't do polygraph tests anymore for the restrictions. So let's go to substance abuse and how it affects employers financially. Well, it is anticipated by the U.S. Office of National Drug Control Policy that about 8% of employees are drug abusers, and those persons create significantly more employer medical and workers' compensation claims. So it can increase absenteeism, pay for absent employee, pay for fill-in staff, again, more accidents, medical expenses, wages of temporary employees to fill those employees, replacement of damaged equipment, legal investigation fees, higher health care needs, increased insurance costs, employee lost time, administrative costs, unproductive hours of work, replacement of stolen items, fees for hiring security services, and legal fees and investigation costs. It's huge. It's really can be quite overwhelming for employers financially. So, substance abuse and drug testing. The Americans with Disabilities Act really protects for alcoholism as a disability, but that dependency on illegal drugs is not covered. However, under the Family Medical Leave Act, substance abuse, drug use, can be covered under the Family Medical Leave Act. And then most of us really adhere to the Drug-Free Workplace Act of 1988, which required government contractors to take steps in eliminating employee drug use. And most employers have comply with Drug-Free Workplace Act, even if they're not a government contractor. And what that does is it allows for policies for conducting drug tests, random testing of all employees at periodic intervals, testing only in cases of probable cause, testing after accidents, and then really, what are the test conditions? Are they job-related consequences? Do they outweigh the privacy concerns? Are the tests accurate? And do you have accurate procedures are available? Did you get the written consent of the employee? Are the results treated confidentially? Does the employer have a drug program, including an EAP, that really can help the employee once found with a potential drug or alcohol problem? So, what are the HR policies, what's procedures, and what are rules? So, really, policies are the general guidelines that focuses organizational actions. Why do we do it? Procedures are the customary methods of handling the activities, how we do it. And then the rules are specific guidelines that regulate and restrict the behavior of employees, the limits on what we do. And that all goes into employee rights. So typical divisions of HR responsibilities for policies, procedures, and rules. On the left side is what the HR practitioners are responsible, and on the right is what the managers are responsible. So HR practitioners design formal mechanisms for coordinating HR policies, assist in development of organization-wide HR policies, procedures, and rules, provides information on application of HR policies, procedures, and rules, trains managers to administer policies, procedures, and rules. Managers help in developing HR policies and rules, review policies and rules with all employees, apply the HR policies, rules, procedures, explains rules and policies to all employees, and gives feedback on effectiveness of those rules. So why do we need handbooks? Well, it's a great guideline for our employees. And these are the elements that are usually covered in a handbook. At will statements, harassment, electronic communication, pay and benefits, discipline, and hours worked. So legal review of language. So you want to eliminate controversial phrases like words like permanent employee. That may be described as an employee. That's going to violate your employment at will. Permanent looks as if you've got a contract with somebody. Using disclaimers, right? Usually, generally use disclaimers. They usually uphold in court, disavowing that the handbook as a contract. So it's not intended to be a contract. It keeps your at-will statement alive. And then keep the handbook content current. And that is really a challenge for most of us in the HR world because so much is changing, social media, so forth and so on. And then make sure it's readable. I mean, adjust the reading level of handbook to the intended audience. And then many of you have bilingual places where you have a high degree of Hispanic employees. You may want to put your handbooks in Spanish as well. And then, use them. Communicate and discuss the handbook. Notify all the employees when the handbook changes is really critical. So, communicating HR information is both a downward communication and an upward. Downward communication means that it flows from top management to the rest of the organization and informs employees about the expectation and goals of the top management. Upward communication enables managers to learn about the ideas and concerns and information needs of their employees. So, let's discuss employee discipline. It's a form of training that enforces organizational rules. Effective discipline focuses on problem behaviors, not at the employees personally. It supports the distributive and procedural justice in organization, and it relies on supervisors and managers who are properly trained on when and how to use discipline. And these are reasons why managers might not use discipline. And it's very detailed in your book, but the organizational culture may not be one that wants to give discipline. They avoid it. Managers may feel they have a lack of support by higher management if they give an employee discipline. They feel guilty themselves as managers because they may have done that before as an employee, and now they're disciplining their employees for doing the same thing they may have done. They fear the loss of friendship with their employees. They're trying to avoid the time it takes, because it takes a lot of time to give discipline, time and effort. And then there's a fear of lawsuits. So, what's the positive approach to discipline? Well, it's counseling, written documentation, and then final warning and discharge. And this chart gives you the progressive discipline process most companies go through. The first offense is usually a verbal caution. The second offense is a written reprimand. The third offense is a suspension. And then the fourth offense is discharge. And discharge is when an employee is removed from a job at the employer. So, I know this was a large chapter. I hope you found this webinar helpful. As always, if you have any questions, please post it out on the discussion board. Thanks for attending.